we get you back into court, a quick update out of Florida in the buried in the backyard murder trial.
Defendant Lori Shaver is accused of fatally shooting her estranged husband, Michael, burying him in the backyard, and then impersonating him on social media to avoid suspicion from his friends and family.
And moments ago, the associate medical examiner at the time of the investigation testified as to his opinion of Michael's cause and manner of death. Let's take a listen.
What was the cause of death of Michael Shaver?
In my opinion, gunshot wound of head.
And what did you determine the manner of death to be?
In my opinion, homicide.
What they cannot tell us, though, is exactly when it happened.
Exactly.
They have sort of a honor about the 7th to the 10th,
Right.
something along that line. All right, we'll keep you updated on that trial throughout the day here at Court TV.
And now back to Mississippi, where we're following the pretrial hearing for the defendant, 14-year-old, now 15-year-old Carly Gregg. The young teen is accused of killing her mother earlier this year and then attempting to kill her stepfather.
Now, Gregg was ruled competent to stand trial and recently turned down a 40-year plea deal from prosecutors back in July. She'll now face a jury beginning next week. Let's get you back in court now to hear more from today's hearing, and we should get the judge's ruling at some point in just a few minutes on that motion.
I believe that Missouri versus McNeely deals with warrants for blood draws, and in this case, we're talking about a urine screen. Also, Mr. Camp mentioned the laws in Mississippi and the statutes about calibration, and I believe what he's referenced it to is the implied consent law, which talks about intoxilizers, not the drug urine screens. Again, we believe that this does fall within the exceptions as cited in our amended response and also argued today. And more importantly, we believe that it falls within Ms. Gregg's medical records upon which she's waived any privilege to, as well as under Rule 703, and that our experts should be allowed to rely upon the presence of marijuana in her system at or near the time of the crime, including the day after the offense, to render his opinions regarding her mental state at the time. We ask that the urine drug screen not be suppressed in its entirety, Your Honor.
All right. This court looked at several different cases, in particular Skinner, Von Raab, Vernonia, Maryland versus King. In addition, the court also read Chandler versus Miller and Ferguson versus City of Charleston. In this particular case, because the need for a warrant is greatly diminished here, where the arrestee was already in valid police custody for a serious offense supported by probable cause, the search is analyzed by reference to reasonableness, not individualized suspicion. Reasonableness is determined by weighing the promotion of a legitimate governmental interest against the degree to which the search intrudes upon an individual's privacy. The court would find that the government has there's a legitimate governmental interest in determining whether or not somebody is under the influence in the juvenile detention center, not for the purposes of prosecution, but for the purposes of safety of the accused. Obviously, like Mr. Gerber testified, if somebody tested positive for fentanyl, there are serious withdrawal issues. Well documented. It's not hard to find that out there. I'm not sure the Juvenile Detention Center is equipped to handle those type of situations. There's a valid governmental reason to do it. Looking at Skinner, Von Raab, and Vernonia, the court believes that falls into that. Additionally, the court looked at Jones versus State, Mississippi case cited 881 Southern 2nd 209. The physician-patient privilege was waived in this particular case, and in Jones, the evidence was actually used to prosecute the person. That was not the intent of this evidence. The intent of this evidence was to find out whether or not there was a critical medical need that needed to be assessed at that moment. Now, the court would have a different holding if the state was attempting to offer this to prove possession of cannabinoids or some other crime, but that's not what it's being offered for. In retrospect, the state was able to go back and look at that and raise it for the defendant's insanity defense. So for those reasons, in the case law cited, Maryland versus King, the court would also find that a urine analysis is the least invasive and most reliable method to obtain a drug screen. A needle would be very invasive. Buccal swabs are not considered to be very reliable, the saliva type testing. Hair testing is invasive. You're removing a piece of hair from the child's body. And in addition, the reliability of those in short periods of time are not where they need to be, so to speak. It shows too great of a window. So for those reasons, the court is going to deny the motion to suppress. However, the court is going to restrict the state you're not to get into this in your case in chief. It can only be used if and when the defendant raises their insanity defense. That'll be the court's rule and the state's to give me an order. All right. Next matter was a motion for gag order document number 177. The response was filed late. As such, it will not be considered.
Still with us, trial attorney Bruce Rosenberg. All right, Bruce, let's talk about exactly what that means when the judge says, okay, state, you cannot use this drug screen in your case in chief. However, you can use it in rebuttal if the defense does put up evidence of insanity defense.
Well, Judge, I guess the point is that we don't know yet for certain what the defense will put forward in the trial. So what the judge is saying is that this evidence cannot be used by the prosecution to establish its case in chief or to prove the innocence or guilt of the defendant to the charge of murder. But if the defense decides to go ahead with an insanity defense, meaning that the reason that she should not be held accountable is because she was not mentally competent, then at that point, the judge has ruled that the prosecutor can then use this evidence to rebut the presumption that somehow she was insane at the time. And I'm not sure how that plays out, but that's what the judge has said.
Bruce, I'll tell you how it plays out. It means it's coming in because there's really no other way for the defense to go in here but an insanity defense. So you know that's happening. You're going to hear about this on rebuttal. But as a defense attorney, when you look at it, they do have a little bit of an ace in the hole in that they can attack it the same way he was attacking it in this hearing. We don't know who did the test. We don't have anything that says it's a really super accurate test because it's more of a screening than an actual test or a panel, the way these are normally done, not normally used for evidentiary reasons. So he can bring some doubt as to that result as well. That's what he's going to have to do.
I agree, Michael, absolutely. But, you know, in the end, I guess I'm not so sure how cannabis as a drug being utilized by a defendant plays into a violent murder. Again, it's more of a sedative than it is an active a drug. But I agree. I think it leaves the door open for Mr. Camp to utilize each one of those points and hit the nerve directly about no probable cause, no warrant, no consent. All those points, great points, and but still, as I said before, it's one piece of it, one pixel in a picture, and yes, it gives the defense something to work with, but is it going to be enough? I don't think so.
All right, thank you so much to Bruce Rosenberg for joining us this hour.
All right, folks, stick around. Coming up, more from that motions hearing for Carly Gregg. We'll be right back. So keep it here on Court TV, your front row seat to justice.